possible for you to do a recording and have this sent to those who are not able to join?
We will be recording the meeting. We can, but we will not be able to share the recording, sir. Unfortunately, because that will be our own that's privilege amongst us, sir. Because everyone will be able to see everything then. So we won't be able to share the recording, but we will be recording the meeting.
Can we get started, Ms. Samia?
Yes, I think we'll get started. I'll just mute everyone. Good morning, everyone. We are calling all purchasers because we've sent a circular around to all purchasers of True Renaissance Empire Remix 1, basically informing them that we have procured a white knight contractor, we have signed a master agreement, and that we're proceeding to sign the supplementary agreement. Now, if you have seen your circulars, if you've read your circulars, you will see that there is an update on what has happened, mainly that who's the white knight contractor and what is the next steps. So now why we organize this meeting is mainly because purchasers have a lot of questions, whereby because we have asked, of course, purchasers to appoint solicitors and and to execute the supplementary agreement. So of course, purchasers have a lot of questions. So we've organized this meeting just so that we can clarify some things. And if there's any further clarifications you require, we can go ahead and do that as well. So right now, I will just share screen to just show some slides, and then we can proceed further. Just give me a minute. All right. So let me just go through the slides, and then we will open the floor for Q&A. All right. So this is as mentioned in the circular. We have informed you that we've appointed a white knight contractor, mainly HCK Central Bahad, and we have signed the master agreement. So what is the master agreement? Why are we doing this? Since the project is abandoned, of course, we need a white knight contractor to complete the project, all right? And in order to bind us with the white knight contractor, and so that there's no issues in the future, or if there's any issues, we have a contract in the future, we have entered something called a master agreement. So the main clauses in the master agreement, I think that is what purchasers need to know. So the main clauses in the master agreement are as follows. Of course, the master agreement is signed between True Renaissance, Project Mora, which is your proprietor, HCK Properties, which is the holding company of the white knight contractor, which is HCK Central. All right. So we are not just going with the $2 company or anything. We are making sure that the HCK Properties, which is a very prominent, good company, long-standing company, has a privity of contract with us, so that people can, of course, we have a better bet in the future. All right. Commencement date. So commencement date is when are they going to start constructing the project. So right now, what has happened is we have given, after signing the agreement, we signed the agreement on the 7th of January 2026, we have given them the vacant possession. So as soon as we give them the vacant possession, of course, they go on the property. They need to first get all the approvals and all the plans in place. So commencement date will be 12 months from the date of the master agreement. All right. Thereafter, 3 months from the date of the approval. So for 12 months, they can, of course, write to all the government agencies to get their approvals, get their whatever plans they need to get, and then from there they have 3 months to finalize the plans and get their approvals. All right. Then completion date will be 5 years from the date of the last approval. Now there's of course quite a few blocks that are going in, so they are going, in order to make sure that the construction starts as fast as possible, they're going with whichever approval they get, they're going to build that. All right. So the date of last approval, so if there's 5-7 blocks, whichever block gets the last approval, they will have to get that. It'll be 5 years from that. So the reason why this is still we are not sure with the end what the beginning end game or the beginning starting game is, mainly because we haven't got the approvals yet. So once the approvals, we get the dates in hand, we can tell you what is the last date which is the completion date. All right. Then this is one of the clauses that HCK, of course, since they are using the progressive billings to the balanced progressive billings to complete the project. This is what they had us put in. Existing purchasers will have to proceed with their progressive payments. If they fail to get the progressive payments, of course the property will be surrendered to HCK. This is mainly because if you don't pay your purchase price, if you've not finished paying your purchase price, so if it's like 40%, 60%, if you haven't paid your 40 and you haven't paid your balance purchase price, of course it'll be rendered an unsold unit. If progressive billing is already 90%, then of course this or 100%, of course this clause does not bind you in any way. All right. Then there is also a good news. This is the best news we could get. There'll be no top up by any of the purchasers. So that is an excellent news for purchaser, because of course right now we know that with True Renaissance there's already a 90%. Most units have already got a 90% pay drawdown already. So there's only 10% left for HCK. So of course they have to source for their own funding. So, but in view of that, irrespective of the fact that 90% has paid and they have only 10% left, the HCK Central has agreed that there's no top up by any purchasers. Right, so I can just go to the next slide. So in view of no top up to by any purchasers, of course your LED claim and DIBS claims will be hit. They'll have to be waived, because HCK cannot be paying purchasers their LED claims and their DIBS claims if they have to if there's no top up and they have to complete the project. Of course, all that money is going to be used for you to complete the construction. So the main goal for us right now is to ensure that purchasers get a unit in their hands, rather than having an empty nowhere to go and just chase after LED claims and DIBS claims. So our main goal is to ensure that the purchasers get a unit in their hands. All right. So HCK is agreed for a buyback option, but at the completion of construction at the rate of 800 ringgit per square feet. So at the end of construction, if you still can't find, if of course you don't want the unit and you cannot find a purchaser, HCK has agreed to buy back all your unit at 800 ringgit per square feet. Okay. Any purchases with financing, the progress payment shall be released directly to HCK's project account. So now what is happening is, earlier we used to have a True Renaissance project account. So now that project account is going to cease, and we're going to we are opening another project account under HCK. So all financials will now pay all balance drawdowns to the HCK project account, and this project account will be all the proceeds that go to this project account will be used by HCK to complete the project. And as liquidators of True Renaissance, we are a viewer of the project account, so we can keep an eye on what is happening with the money, unlike what we had in the earlier situation when, of course, we were not sure whether True Renaissance was using it for constructions or for whatever gains that they have. All right, and any Bhumiputra release letter. So basically, being in the state of Selangor, you have something called Bhumiputra quotas. So we are not sure how much is the quota exactly, but HCK has undertaken that any units that have Bhumiputra issues, which is supposed to be sold to a Bhumiputra and it's sold to a non-Bhumiputra, they will ensure that the release letters are sought and they will pay the premiums. So this burden will not fall on the purchasers. So this is another excellent thing that HCK has proceeded, because if you see the news nowadays, there's a lot of issues with Bhumi quota issues that's going around in Selangor. So this is excellent that the purchasers do not have to worry about this. All right. So these are all the important clauses of the master agreement that the purchasers have to know. So what is the next step? After us completing the master agreement, what are we going to do? So the now liquidator is writing to all the purchasers to inform them to execute the supplementary agreement. So that is the circular that you've already received, which is why you are here today. So that we've written to most of the purchasers, almost more than 50%, to all the purchasers, asking them to do the supplementary agreement. So in order to execute the supplementary agreement, we need solicitors on board. So I will explain to you why we need the solicitors on board. I think this is the agreements that everyone is talking about. All right. And the fees, of course, once the solicitors on board, we are going to inform them as well. The fees for the liquidators, solicitors as well is 1,620, which is 1,000 ringgit legal fees, 500 disbursement, and 120 ringgit, which is the 8% SST, which will be imposed by the liquidator solicitors for drafting the supplemental agreement and drafting the master agreement and all other services. So all other services will include your signing with HCK, going around checking the documents and everything. Again, this part also, we have a separate slide for you. I will explain to you what exactly encompasses the 1,620. All right, so this is per purchaser. So we are, as liquidator, we have to do 2,000 contracts. Okay, it's 2,000 plus purchases. So we have to do 2,000 separate. We look at 2,000 separate contracts, 2,000 separate particulars. Everything will be different for each purchaser. So even though the clauses remain the same, the particulars and the execution is different, and per purchaser, so it's the same same work we have to do per purchaser 2,000 times. All right, so that's why per purchaser we are charging 1,620, which is going to the liquidator solicitor separately. It's not coming to it's not liquidator's fee. All right. Thereafter, liquidators will provide the details of documents required for verification purposes. So once your solicitor writes to us and say, yes, I'll be representing purchaser ABC, we will write back to them, giving them a detail of all the documents we need. We're going to give them details of what we want from the bank. If you've got an end financier, we'll request confirmations and undertakings from the end financier and all the details required. If you are a cash purchaser, again, we'll give you confirmation and undertaking that's required for cash purchaser as well. So this we will provide once you appoint your solicitors, all right, with the supplemental agreement. So you'll have to appoint your solicitors so that we can explain, you'll have details of all the undertakings required. And upon satisfaction, you can sign and execute the supplemental agreements. All right. So another thing we have to look for, another second part of it, is that all sale and purchase agreements of unverified purchasers who've not proved the beneficial ownership will be terminated and classified as unsold unit. So if you do not come forward and you do not prove your ownership, then we'll have to classify you as unsold, as the unit as unsold unit. This is mainly because once we stepped into the shoes of the liquidator, they did not provide us any documents. We are going with an empty shell of a company where we have no documents. So it is the burden on the purchasers to prove their ownership. All right. We with the list that we have from previous proceedings and everything, and of course falling out from word of mouth, we have been able to send out the letters to how many other people that we can. Of course, people are coming back to us. So as when they come back to us, we are sending it to them. So, but document-wise, we have no conveyancing documents from any of the purchasers or from any of the previous submissions or anything. So this is why purchasers have to come to us with their documents. We cannot go pick from any of their offices or from True Renaissance offices or from the previous CVA offices or anything. All right. The liquidator will vest all the unsold units for the benefit of HCK. So another way HCK is financing the construction is that any units that are unsold, they are going to sell, and those proceeds will be used for the construction of the unit. So everything, any money that we are getting from any asset of the company, it's being processed to HCK so they can complete their construction. All right. Upon completion of all supplementary agreements, the liquidator will file a scheme of arrangement to bind the arrangement with parties. So what we are doing is that, of course, you have a contractual agreement. You have a privity of contract with HCK by way of the supplementary agreement. We are also filing something called a scheme of arrangement, where we will get an order from court confirming this transaction, so that the purchasers, even with the agreement, they also have a court order in case something goes south tomorrow. So you have a contract to go back on, and you have orders to go for committal proceedings or anything in the future. So there's two things. So you're protected by two documents over here. All right. So I'll just explain on the scheme of arrangement a little further. So we are doing something called, like earlier it was called a 360. It's called a 366 scheme. So what a scheme of arrangement does is that we call all the purchasers forward. We we file an application in court, informing the court that this is the scheme, this is the process that we are doing, this is the plan that is forward, and the purchasers will have to vote on this. So we usually get 75% vote. So what we are doing is with the supplemental agreement. So if there's about 2,000 purchasers, or 1,000 purchasers, 800 of them have already signed the supplemental agreement. So all 1,000 will be part of the scheme of arrangement. So 800 purchasers will, of course, since they've signed the supplementary agreement, of course, we can be sure that they are agreeable to the transaction. The balance 200, what are we going to do with the balance 200? They will have to appoint solicitors to come to court, explain what is the issue, appoint a solicitors, give us the documents, and then sign the scheme, then sign the supplemental agreement. So either you're going to do it here or you're going to do it at the scheme of arrangement. The scheme of arrangement will be more expensive because you have to appoint solicitors for litigation purposes. All right, and of course the liquidators fees for solicitors will also go up, because irrespective of just going to doing the supplemental agreement, which is a simple contract, they'll have to, the liquidators will have to now file, liquidators lawyers will have to now file something in court. So that is additional fees. So you're going to incur more costs. This is why we are doing the scheme. Rather than proceeding with the scheme of arrangement in its totality, we are starting with a supplemental agreement to decrease the fees for the purchasers. So that at the end of the day, we are hoping that, of course, they're all 1,000 purchasers or 2,000 purchasers come forward, and we can just go for the scheme of arrangement and get a sanction from court. If that will be the easiest way. But of course, if purchases are going to be difficult and they do not come forward, we will have to impose further fees, and they will be incurring further fees by appointing their solicitors to come to court. So this is what we're going. If you can read what is on the slide, it is, of course, purchasers who do not sign the supplemental agreement. The liquidator will file a scheme of arrangement. As per the scheme of arrangement, the unverified purchasers will have to comply with the following. So they'll have to appoint solicitors and participate in the scheme of arrangement. They'll have to appoint solicitors to provide the documents and then execute a supplemental agreement. Any unverified purchase, all the unverified purchasers will have to pay the liquidators additional fees, because this is going to impose not just the supplemental agreement fees, but this is also going to impose your scheme of arrangement fees. All right. The verified purchasers will be exempt from this exercise, because of course they've signed the supplemental agreement. And any purchasers who do not participate in either of these procedures, those units are going to be considered unsold units, and they're going to be handed over to HCK for the to finish the construction. Okay, so we have a couple of FAQs already answered, because this is, of course, the most common questions we get asked. So we've just gone forward and provided answers for you. So what is the role of the purchaser solicitors, and why do you have to appoint? So this is what purchasers are asking. Why can't I do this myself? Why do I have to appoint solicitors? This is the reason. Okay, the lawyer will have to first abide by the request of the liquidator, which is CTC all the documents. So only a lawyer can CTC all documents, right? So since we were not there, the liquidator was not there at the execution of these contracts, we will need CTC of all documents, making sure that we are getting the certified true copy of all documents. All right, the lawyer will provide an undertaking. So this is an important step for us, because we need an undertaking from the lawyer that all the details are correct. So we will ask for details about the bank transactions or the drawdowns. So what is the total loan amount? How much drawdowns are already been done? So these are all the details that the lawyer has to give us, and they have to give us undertaking this detail is true, and that all the details they're giving us is true and correct. All right, so this is an undertaking that lawyers have to give us, and we cannot have purchasers who have no legal background or understanding to give us such undertakings. Okay, the lawyer will also have liaise with and financing bankers in order to procure all the details. So we are going to give you, with the first letter, we're going to give you 2 other letters that have to be executed on the bank's letterhead. So basically, what the banks will have to undertake is that, of course, all the details, they have to give us all the loan details, all the drawdown details, everything that they've done so far, and they have to also go forward and give an undertaking and consent that no KVs will be lodged on the master title, all right, and that they consent for the purchasers to execute the supplemental agreement, because as end financials they have a beneficial right on your property, so they have to consent for purchasers to sign execute the supplemental agreement. Then they have to consent for HCK to not to encumber that to allow HCK to encumber the master title, because HCK of course will be financing the master title to get their financing for construction of the property of the project. So they have to allow for that. Then the total loan amount approved and all the balance loan that is released, they have to give an undertaking that all these details are correct. Then furthermore, the lawyers will also have to give an undertaking that they give us back the duly executed and stamped supplemental agreements to the purchaser and to us, give a copy to the liquidator as well. All right. So the lawyers will have to fill in all the details in the supplemental agreement. So we will give them the draft, the specimen supplemental agreement. It is the lawyer's duty to fill in all the details for you. The lawyer will have to read the supplemental agreement and explain all the terms of the supplemental agreement, because this is a complicated contract. This is not going to be a run-of-the-mill HTA sale and purchase agreement. It's a very complicated contract which the lawyer has to explain to you. And of course, they will sign and attest and witness the signing of the supplemental agreement. And of course, they will proceed to stamp the supplemental agreement. So this is all the duties what a lawyer has to do and what cannot be done by a purchaser. This is why we want them to want all purchasers to appoint a lawyer. Now, same for a cash purchaser. Okay, what is the role of the liquidators solicitors? So of course, we are also charging 1,620 for 1,000 ringgit legal fees for purchasers, for the lawyers, liquidators solicitor. So now we've already drafted the supplemental agreement, which is already complicated. So we've already drafted the supplemental agreement. The second step will be that we'll have to provide all of this to each of the lawyer. Once the purchaser give us the details, we'll have to our lawyer is the one that verifies all the documents are in order. Our lawyer is the one that checks all the information. So for 2,000 purchases, we have to check 2,000 documents, 2,000 sets of documents, all right? And we'll have to check 2,000 contracts for each and every one to check whether the details are correct. And then this is going to be the supplemental agreement is going to be signed by the liquidator, signed by the purchaser, signed by Project Mora, and signed by 2 HCK companies, so HCK Central and HCK Property. So it's five people who are signing the supplemental agreement. So your lawyer, of course, will sign on behalf. Will make sure that your signature is there. But our lawyer will make sure that, of course, the liquidator signature is there, and Project Mora signature, both the HCK signature. So we make sure that you get 4 signatures on board. All right. So your lawyer will take care of your signature. We have to do for all other 4 signatures. For cash purchasers, why do they have to appoint? Again, this is the normal question we get asked. I have all the documents. I don't need a lawyer. I'm a cash purchaser. There's no need to liaise with the bank. Again, that's not the point. There's other things to do other than liaising with the bank. Of course, the lawyer will have to CTC. The lawyer have to provide the undertaking that all your documents are true, and there is no and there's no forgery, or hopefully there's no such things, and all the details are true. They have to request the liquidator will have to will request for the consent agreement again. So the lawyer will have to ensure that your undertakings are done properly. They will fill in all your details. They'll have to read and explain the document to you, attest and witness the signing of the supplemental agreement, and of course stamp your supplemental agreement. So other than liaising with the end financials, your lawyer will have to do everything else. Even for a cash purchases, it doesn't matter whether you're a purchaser with a loan or cash purchasers. It's the same task they'll have to do. Okay. Consequences of not appointing a lawyer and signing the supplemental agreement. Now, of course, this is where the scheme of arrangement comes into place. So again, unverified purchaser will have to appoint solicitors for them the scheme of arrangement. So as soon as you say that as soon as you tell a lawyer that they have to go to court, especially high court, the prices go up glaringly. There's no way you'll get a lawyer less than 50,000 in the market. All right. So this is why we started the supplemental agreement before we started the scheme of arrangement, because we don't want purchasers to be burdened with this. So if you get it done now, it'll be way cheaper with the supplemental agreement rather than you informing your lawyer that you'll have to go to court for a high court matter. All right. At the stage of supplemental agreement, of course, the liquidator's cost will go up because we had to file something in high court. So our costs have gone up because for a scheme of arrangement, it's not filing of documents. We have to affirm all the documents. We'll have to advertise. We'll have to do the government gazette. We'll have to do a creditors meeting. We'll have to book the hall for creditors meeting. So this is all money that's going out of our pockets, and this is all money that is the lawyer will have to all the work that the lawyer will have to do. All right. So of course our costs will go up. And if you don't come forward, it's regarded an unsolved unit and we relinquish the HCK. Okay, so I just want to touch on the undertakings again, so you understand what the lawyer will have to undertake, because they are the ones with the license to give such undertakings. Again, we'll have to provide that all information given at the time is true. They'll have to give an undertaking that the document duly executed and stamped supplemental agreement. So it's not just simply signed papers that are coming forward. It's duly executed and stamped supplemental agreements are coming forward. That they have to get a consent and confirmation from the end financiers or the cash purchasers that they, as I've mentioned earlier, that the master title is charged, that the undertaking that there's no caveats placed on the master title, that all the details are correct. So they'll have to give such confirmations and consent. And of course, without legal knowledge, we will not be able to get these undertakings from a layperson. So we will have to have a lawyer to be present to do all this. With no legal background, we cannot have purchasers giving us such undertakings. So I think this is a brief overview of all the an update on what is going on, and brief thing that we have questions that we have answered. We'll open the floor for further questions. I think you can unmute and just ask your question.
I think if I could just assist, thank you, Ms. Ramya. I will help to moderate between the purchasers and the liquidators. So please, you can ask your questions, or we can start reading out your questions from the chat room.
Hi.
Go
Can
ahead,
you hear me?
ma'am. Yes, ma'am. Go
For
ahead.
my case, right, my mortgage loan has already been converted to a term loan by my bank. So how do I go about it if I choose to embark or participate in this supplemental agreement with the new White Knight?
Can I invite Ms. B to answer this question? Ms. B.
Good afternoon, ma'am. You just have to continuously service your term loan, and please request your lawyer to write an official letter, and we will guide your lawyer, and we will request your lawyer to write an official letter to your financier and get some confirmation and details from them. So please do not stop your installment. Please continue, and we will advise your lawyer accordingly. Thank you.
Okay, but for my case, the term loan was disbursed previously for about 50% instead of the 100%.
Yes, ma'am. We
So-
will advise for that. So your lawyer just have to get a confirmation from the bank how much loan has been approved for your unit and how much drawdown has been happened and what is the balance in the loan amount to disburse. So that's the reason we are preparing the supplementary agreement. Upon your lawyer get a confirmation from the financier, they will incorporate all this information in supplementary agreement, and we will advise your financier drawdown upon receive the progressive billing. The drawdown have to directly go to the HCK account.
So okay, thank you. If I understand you correctly, what you mean is that I have to appoint my lawyer, and then my lawyer need to talk to my bank to say that they have to
Yes.
activate back my remaining of the 50% into a mortgage loan, and then this undisbursed 50% mortgage loan will be disbursed to HCK. But then at the same time, I have to service both loan, which is the term loan, and the impending new mortgage loan, which is to be disbursed to HCK if I want to participate in this scheme. Am I right?
Yes, ma'am, you're right. Thank you.
Okay, Ms. Ewan.
Okay, thank you.
Thank you. Can I have a next question?
Okay,
Yes.
hello. If I use the lawyer proposed by you, where I paid 1,620, will the lawyer do all the verification, or do I still need to find my own lawyer?
Mr. Hawk, maybe I'll take this question. There are two sets of lawyers here. The one that has been posted here is for the liquidator. Their lawyers are called Susilan and Associates. You're paying for the liquidator's lawyer and the liquidator, so that's 2 in 1. If you have your own lawyer, please go ahead and deal with your lawyer. If you want to use a lawyer recommended, the present liquidator is working with a few lawyers. That one, they can post the name there. I think the fees, Miss B, can you just confirm how much the fees?
Currently, the lawyer they are appointing Hakim Arabian Associate, charging 1,000 as the legal fees, disbursement 500, and as a 320. So they are also charging a very minimum fees because we have requested them not to charge the purchasers a lot because some of the purchasers complain. Lawyers are demanding for 3,000 and 2,500, 4,000. So we did our survey and we got the cheapest. So whoever want to proceed with this legal firm, we can give your contact details here in the chat group. Thank you.
So what's the fee they are charging again?
They're charging 1,000.
Total.
1,000 and disbursement 500 and 8% SST. Same as the Sicilian Associate.
Okay.
Because we told them that because some of the purchasers are complaining, the lawyer they are charging 2,000 and 3,000. They are already in a pain, so we don't want that. So that's the reason. When we did the survey, this is the cheapest. So we leave it to the purchasers to select their own lawyers.
Okay. All right. Thank you.
Let me remind you, you're free to. Thank you, Mr. Hawk. You're free to find your own lawyer. If you can get some lawyer charging even cheaper, by all means, please go and get your own lawyer. Can I deal with Mr. Stanley? He's raised his hands. Mr. Stanley Wu.
Hi, thank you so much for giving me the airtime. I would like to just to be sure, you mentioned that there are 2 sets of lawyers, right? The 1,600 is the net that we have to pay, or do you have to 1,600 times 2?
Right now, the liquidator is only asking you to pay to the liquidator's lawyer, that is Susilan and Associates. That covers their lawyer's fee and their liquidator's fee as well, right? Now, in terms of you engaging your own lawyer, please remember, we are not recommending anyone. But there are some lawyers already acting. They're just giving a name in case you want to use that name. You're free to go and get any lawyer. If you already have your own existing lawyer, please go to them.
Yes, understood. So thank you, sir. So just want to confirm that 1,600 is for the price for the two sets of lawyers. Is that correct?
No. 1,600, yes, the same amount, but it just happens to be the same figure. I would want to stress, let us just deal with the liquidator and the liquidator's lawyer's fee. That's it.
I just want to confirm: is it like 1,600 net, or is it 1,600 times 2?
If you're using are you using the liquidator, or are you using? Sorry, are you using your own lawyer, sir? Maybe that's.
No, let's say if I do not choose my lawyer, I choose the one everything.
You want to choose your lawyer. You want to use the one most people are using. Yes, it's 1,620 times 2. But you're paying separately. Ms. B, can I confirm that?
Yes, sir, you are right. We will share the contact details here. Lawyer in charge is Mr. Dharmin. Please feel free to call him directly, then he will advise you. We don't want to be involved in this, introducing any lawyers. Better purchaser directly call the lawyer in charge and speak to them and get their advice. Thank you.
Mr. Stanley, is that okay?
Yes, sir. Thank you so much.
Thank you. We'll go slow, don't worry. We'll go slow, we'll take our time, we'll explain everything to you. If you don't understand, we'll give you time to keep asking the question until you're happy with our explanation. Next person, we have Mr. JC. Mr. JC, can I have Mr. JC first?
Yes, just one
Yes,
question. Why are individual purchasers paying for the liquidators listers instead of the creditors as a whole?
Okay, so the answer is very simple, Mr. JC. Actually, you're paying the liquidator. You just happen to be paying into the liquidation lawyer's account, Mr. JC, because if you're not paying to the liquidator's lawyer's account or paying the liquidator, no one is paying. HCK is not prepared to pay any fees to the liquidator whatsoever, Mr. JC.
Yep.
So remember, the liquidator is dealing with the 2,000, the supposed 2,000 units of buyers who, at the moment, we can't even trace. So all the work being done is actually done for the purchaser's benefit, not even for HCK's benefit. So HCK doesn't want to pay the liquidator anything, and we are talking about a time frame of maybe up to 7 years that the liquidator has to help you monitor the drawdown of monies, liaising with the banks. All this is going to take place over a period of 7 years. So there is no other way for the liquidator to be remunerated unless purchasers themselves pay to the liquidator. So JC?
But how is the liquidator remunerated over the course of the liquidation?
Sure. So every payment that you make is going towards that account to be able to compensate
apart
the
from
liquidator
the
over 7 years.
apart from the liquidator's solicitor's fee,
Yes.
how is the liquidator remunerated?
That's it. They're not asking for anything else. It's extremely reasonable considering the fact that they have to do this for 7 years. Nobody is paying them for the scheme of arrangement. Nobody is paying them to verify. There are a lot of dodgy, suspicious sale and purchase agreements that they have to go and check and go through and nullify. All this is being done at the liquidator's cost. So they're not charging for any of this.
There's no fee to the liquidator or payable to the liquidator apart from whatever that the liquidator is recouping from the purchasers.
Correct. The only other fee, living in the interest of transparency, and at the end of the 6 or 7 years when the project is completed, there will be strata transfers. That will be a separate issue. Of course, you pay like a normal developer at that point of time. From now until completion, that's it. So JC?
Sure. Thanks.
Thank you, sir. Next question, we have Ms. SL. Ms. SL has raised her hand.
Hi, okay. I get to get in this Zoom is because someone sent the link to me. So I totally know zero, nothing. So I do not know what is particular and then what is going on. Probably you can give me a brief on that.
So we can't repeat everything, Ms. SL, because it's good that you have come in. What I would suggest to you, you have the summary. Can Ms. Ramya just confirm that, have you received from the liquidator this document?
Nothing. They mean I know
Nothing,
zero.
okay.
Nothing.
All right, can you put your name, Ms. Ramya, can you attend to this? Maybe just
Sure, sir.
help.
Miss SL, just put your unit number and your details, and we will get back to you. And you can also email us. I'll send you our card in the group. In the chat group. You can also email us with the details.
Okay.
Thank you.
I'll write in the message. Thank you. Yes.
Thank you, Ms. SL. Can I deal with Miss or Mr. Radian? Sorry, I don't know.
No problem. Yeah, just one quick question. Just one quick question. So you mentioned that HDK has agreed to buy back upon completion of 800 ringgit per square feet, right? So if we want to opt for that, do we still have to go through this process? We still have, right? I reckon.
Let me explain this, Mr. Radian, if that's your name, Mr. Radian. So this was quite difficult when we were buyers. We were negotiating for about 500 purchasers in terms of what to put in this clause. So what had happened was, judging by the success of Empire Remix 2, Empire Remix 2 was also completed by HDK Group. Many of the purchasers felt that we shouldn't lock down the figure of 800.
Okay.
Now, I'll tell you why. Remember that the buyback clause that they wanted to put in on the 800 ringgit per square foot only kicks in upon completion. Upon completion, with due respect, dear purchasers, might be more than 5 years. We have to anticipate up to 6 to 7 years. All right? So knowing that was the case, many of the purchasers, and of course discussing with their lawyers as well, they all felt, keep it vague, keep it open. Let you all decide upon completion, you may be able to sell to an outside party at a higher price. That's what happened in Empire Remix 2. So learning from the experience of Empire Remix 2, it will not be put, even this agreement will not be placed into the supplemental. Is kept very vague. It's not a commitment. Both parties will be at liberty to either accept it or not accept. Mr. Radian?
Okay, so 800 is still in the text of the agreement.
Yeah, he's happy to pick it up. He says, I'll sign today, but he's not going to pay you today. He's only going to pay you upon completion. So we said, on behalf of all buyers and looking at your interests, why do we want to lock you down today if the price may be higher 6 or 7 years from now?
Understand. So we still have to go through this entire litigation process of appointing 2 lawyers. Even let's say we decide to exercise it.
Yeah, there's no litigation here. It's just someone to keep an eye out for you. That's really what's going on here.
Okay, so we have to go through the process, right? Just to confirm that.
Yes, sir.
Okay,
yes,
thanks.
Yes.
Thanks. Thank you.
Thank you, Mr. Radian. Can I look at Miss Shami Chua, if you don't mind, Miss Shami Chua?
Hey, hi, good afternoon. I'm driving, by the way. I hear all of you were talking now. I just want to have a question here that I have signed with lawyer Richard B, right, to execute the LOE, which is almost the same amount as just now you mentioned, the 1,620. So is this also part of the agreement that you mentioned just now, the supplementary agreements, or this is a different agreement, the LOE?
So I'm assuming Miss B will tell me whether I'm wrong here. I'm assuming he will be your lawyer.
Okay.
Sorry. Ma'am, they're charging 1620 is for what? What agreement, ma'am?
Execute letter of engagement, I think so. LOE.
Please check with your lawyer. Are they going to prepare the supplementary agreement for you? In the event, yes, please request them to write an official letter to us and we will reply to them accordingly. Currently, I'm not so sure they're charging for.
Miss B, I need to interject. Miss Sammy, I think this is your solicitor. Is you are paying for the services. The 1,620 that you'll be paying towards the liquidated solicitor is separate altogether. All right. So this got nothing to do with the liquidator solicitor. This is you are paying. It's a coincidence that Richard Wee is charging the same amount as the. Yeah. Okay. So it's two different things. So now I have to go back to my solicitor and ask about these supplementary agreements, right? Yeah, you actually have to ask them to require them to write to us, and we will forward the first letter from the liquidator to your lawyer. Okay. Thank you. Welcome. Thank you. If I can get Miss Connie to for a question, Miss Connie. Okay, I think she's busy right now. I'll read some questions from the chat group. Okay, if True Renaissance terminates the sale and purchase agreement and shall be surrendered to HCK as unsold unit, in this case, should the developer pay back the purchaser money already paid? Miss B, do you want to take this question? Hello, sorry. If True Renaissance terminates the sale and purchase agreement and shall be surrendered to HCK as unsold unit, right? Is this case should be the developer pay back the purchaser's money already paid? Okay.
Currently, the S&P is still valid. He's just preparing supplementary agreement to introduce the HCK as the white knight to complete the transaction. So consider we are not revoking the S&P and we are continuing with the S&P. So we won't be pay back whatever the amount paid to the True Renaissance. Ms. Ramya?
I think we also need to. Sorry, Miss Mala, do you want to? Just to add on, Ramya, we don't provide this option at this point of time. There's no discussion on having this option available. So unfortunately, it's a no. I think we also need to clarify that units that the purchasers that don't come forward will be considered as an unsold unit. So if you don't sign this, don't come forward and don't sign the supplemental agreement, only then you're considered an unsold unit. So if you're coming forward and you're verified, there's no reason for you not to sign the supplemental agreement, because this is for the benefit of all purchasers. This is what is happening. So there is no reason for you not to sign the supplemental agreement. All right. Ms. SL, we will proceed with your circular. We have one question from Mr. Tan. I have not been officially informed via hard copy or soft copy. I'm worried your good office may not have my latest contact. Mr. Tan, I've put a contact card already in the chat group. Kindly just email us your details. We will send you the circular. No worries. Okay. Is the buyback RM 800 condition will be reflected in the supplementary agreement? Ms. B?
The answer is yes, Ms. Ramya.
Okay, you've answered, all right.
We will cover both about the buyback clause and no top-up. These two clauses will be in the supplementary agreement.
Okay. But when do we have to decide, whether to take up or not? Or we don't have to decide when we sign the supplementary agreement? Decide what, sorry? Whether to take up the 800 ringgit offer. But if it's in the supplementary agreement, do we need to decide, or we don't need to decide? You decide only after the construction of the of your unit. So at that time, if you don't want to take up that option, there's no need for you to. So we're just keep the option open in case in the future, in 7 years down the line, you really need to sell your unit and you don't have a buyer, you have the option to sell it to HCK.
Okay.
But
so inside the settlement agreement, it will be included as an option.
It will be, yes,
option.
Correct. It will be an option to purchase, correct.
Okay, so we don't need to decide now. Okay.
You don't need to decide
Glen's
now.
got a lot of lawyer name here. What is the name of the liquidator's lawyer? Can you spell that for us so at least we know?
Susilan and Associates. I can also put it in the chat group also. That's a Susilan and Associates. They are not in the meeting right now, so it's only the liquidators who are in the meeting.
Okay, thanks.
Yeah.
I got one last question. Since we're on the line, because our solicitor or your solicitor have to get to our financier to get our info, right? But because of those data protection, privacy protection, have they agreed to release, or otherwise it become our job to get all the things from bank and then pass to the solicitors? How does it work on this?
Okay, ma'am. Let me answer that. We have received a letter from the bankers. They have said that they need an authorization letter from the owners to appoint the solicitor to get all the relevant information and documents from them. Thereafter, they will provide to the solicitor. So whoever you are appointing a solicitor, they have to prepare an authorization letter where you need to sign, confirming to the bank that you are appointing that firm to get all the relevant information and document from them. Thereafter, bank will provide you your solicitor. That's the reason we say it's better appoint a solicitor, because sometimes banks will be reluctant to liaise with the borrowers also. Because under Data Protection Act, they need some sort of authorization letter to release the information, so that in the event is misused or anything, they know which is the party of misused. So bank also not agree to give any information to us. That's the reason we need to suggest corporation to appoint a lawyer and sign an authorization letter to enable the lawyer, like with the bank, to get all the information and documents from them.
Okay.
Thank you.
Okay. The email that we received from you says that there's a supplementary agreement, but there's none attached.
Sorry, sir. We want the lawyer to write an official letter to us. Thereafter, we will share with them the supplementary agreement. So currently, we want you to submit all the relevant documents to verify the beneficial ownership of the property.
Okay. So today, after today's meeting, so what's the next step we take? Contact you or
you
contact
have to appoint your own solicitors. You have to appoint your solicitor to write an official letter to us. Thereafter, we will reply accordingly.
Oh, let's say I use the one that you recommended.
Yes, sir. You can. I already shared the contact number in the chat group. Please feel free to call Mr. Tarmin. Then he will advise you accordingly.
Okay, thank you.
Thank you.
Hi, I have a question here.
Yes, ma'am.
Okay, my top concern is, is there any guarantee that this new white knight that is taking over would not be met with another abandoned case like what happened in the first place? As in, will this supplemental agreement be governed by Housing Development Act, or is just another commercial SPA?
Can I take that question? Sorry, I got cut off just now. Rabia, can you hear me?
Yes, sir.
Yes, I can.
So this is why we are ensuring. This is why we are ensuring that every purchaser signs the supplemental agreement. So the question is very good. Please remember, as of today, none of you all have any contractual interests or rights or obligations with HCK. Now, to be honest, throughout the negotiations, HCK said we don't need. HCK keeps saying, I don't need the supplemental agreement. We are insisting on behalf of the purchasers, there must be a supplemental agreement. Yeah? Not just as, and don't forget, the second, of course, protection is a scheme of arrangement. Ma'am?
I have a question here. Since you enter into the master agreement, so my question to you is the purchaser right remain fully preserved? So I think in more layman term, is the final delivery unit will be according with the original SPA. So covering the size, layout, floor plan, fitting, shilling and whatnot. So will all, as well all those common facilities be delivered as original approved? So have there been any revision made to the scope of this design?
Okay, we can confirm that what has been agreed, it will be in your master agreement, it will be a supplemental agreement, and we'll also be putting in the scheme of arrangement. In terms of the units that you purchase, same size, same floor, same block. Now, what may change is the outer facade. That may change. Apart from that, everything else is going to be the same. Sir?
So the early birds kind of the gift given all burn.
All burn. No LED, no early bird. In return, of course, there's no top up. Remember that for most of your cases, the architect is over certified. Many cases, they are 90%, 95% certification. So in order to resolve the problem that you don't have to top up any more money, you have to give and take. This is where we are at.
Hello, Ramya?
Yes, ma'am. Yes.
Yeah, back to the question about legal fees. I've engaged my own lawyer, so I pay my lawyer's legal fee, right? And just now you were saying I have to pay for the liquidator's legal fee as well?
Yes, please. The liquidator's lawyer is charging 1,620, including disbursements and taxes.
But then the solicitor is acting for the liquidators. Why are we purchasers paying for that?
Because, ma'am, as the liquidator, we are not allowed to fork out our own money. This is not a project where we are gaining anything. This money does not come into the liquidator's pocket. So we have a liquidator will have to pay the lawyer to do 2,000 contracts, right? So the liquidator has come to an empty shell of a company. There is no money in the bank account. There's no drawdowns left. There's nothing in here. So as a liquidator, otherwise we'll have to pay for 2,000 contracts, which our liquidator is going to do. So that's 1,620 into 2,000. So that's going to be impossible for the liquidator to bear from their own pockets. So and it's also against the law for us to bear from our own pockets. This is why purchasers have to bear the cost for the liquidator's fee, so that we can do this for the benefit of the purchasers.
So if we use the liquidator's lawyer, then we only pay one fee, 1,620.
No, ma'am, because the liquidator's lawyers will be the client is the liquidator. Your solicitors, you're the client. So we do not want you to do a normal developer's project where you have only one liquidator, one lawyer on board. We want to ensure that your lawyer is separate and you understand what you're getting into.
Okay.
And also we have our own lawyer.
Oh, so I still have to engage my own lawyer instead of paying the liquidator's lawyer 2 in 1.
Yes, ma'am.
Can I just add on to what Ms. Ramya is saying? So let us all understand this very clearly. You're not paying the liquidator's lawyer for his lawyer's work. You're paying the liquidator and his lawyer's fee. All that in one. It's one package. We don't want to put a bill for the liquidator's lawyer. So that is why we're asking only one payment for the liquidator's payment to go into the liquidator's lawyer's account. I hope that's very clear for everybody. Yeah, and please remember, the liquidator for the next 7 years doesn't get paid by anybody else to look after your interests. Your interest is not just the master agreement, the supplemental, scheme of arrangement, looking into every single SMP, monitoring whether HCK is doing the work. There's going to be meetings every month. They'll be looking at the accounts. They're also a viewer under the new building account. They will have to keep an eye on whether the work is progressing properly. Yeah?
Mr. Dana, coming back to the question earlier, see there's no top-up cost. So I'm concerned, what if the project cost exceeded the estimate? Who will absorb the overrun? Would there be any provisional clause fixed or subject to the future adjustment clause?
It's in the agreement. There's no additional cost whatsoever to use HCK. That is why we insisted that not just the current developer's name is Subang Central Sdn Bhd. We refused to accept this company. We insisted that the corporate guarantee or the holding company, which is HCK, Ramya, I forget the name, Ramya. HCK what?
HCK Properties, sir. HCK Properties.
Which has over $100 million worth of assets in there. The paid-up capital is quite high, 10 million. We insisted that company is also there. And so this company is strong enough to see it through. And please remember, they are also businessmen. So remember that HCK has 2 blocks of their own. The real reason why HCK is completing this project, they are stuck like a victim, like all of you. Now they need to complete their own 2 blocks, which were sold to them a long time ago. And that is the reason why they are forced to come up with their own money for their own interests. And of course, to make some additional money with the new blocks, sir.
So would that be made known to us? What will be the facade line, also the change in all those layout plan?
So in that sense, we are still waiting. Our teams, our operation team, had a meeting with them last week. We have meetings with them every month. They are waiting for the approval. That they are submitting their new plans now, and we are waiting for the new plans before we can share with you. There is an idea to build 1 or 2 more blocks. There's going to be a change of facade, and even the sequence in terms of how they're going to commence building. We will have to come back to you in a 1-2 months time. Sir?
So for the clarity of the purchasers, so any indication, indicative timeline, the construction is expected to resume?
Okay, so this is also a problem. So when you see the agreements, the time frame we talk about is a 5-year time frame. Now, to be fair to HCK, even as we just gave them the vacant possession of the site, there are a lot of issues now. If you look at the site, even if you go by, there are a lot of issues pertaining to structural integrity. I'm not saying they're going to tear down the whole thing, but there have been concerns now that we just gave them vacant possession. 2 blocks, they are concerned whether they might have to tear it down. Civil and structural engineers are looking at it. So my point is, why I'm telling you this is, they cannot even confirm that they can start the work immediately until they look at these structures. So the way it's drafted, if you notice, it is 5 years upon final approval from Majlis, local council. Sir?
Okay, thank you. So I have one more last question. So you mentioned that we have financial, you see, because what happened is that it's abandoned for too long. We have already fully started the house and then whatever not to prevent the interest bigger. So however, the loan still remain not redeemed out, not discharged. So which will the party to notify the bank on this payment release to the new party, which is a white knight? Question 1. And also
can we answer one at a time? Sorry, Ms. B, can you take this question? Or Ms. Ramya, can you take the question? I can't see it.
Sorry, Ms. Dia, can you just repeat the question? I lost your contact a little bit.
Yeah, I'm talking about for those like us with the financing, right? So this one you mentioned that the payment release have to go to this HCK instead of the origin developer. So who will be the party responsible to notify the bankers or the financer?
So that's where your supplemental agreement comes into place, and that's also why we are giving you the first letter. So with the first letter, what we'll do is we'll have some confirmations and we'll give the specimen to your bankers. So in that, we will notify the bankers that that from the future, the progressive billings will all be into this separate bank account. So it's also there in your supplemental agreement that the bank account will be changed once the supplemental agreement will be provided. So we will inform your bankers.
So that still go back to my so-called appointed solicitor, huh? Okay. Yeah. Next question on the proof of the ownership. I'm a bit confused because you see, this is under financing, it's given under the bank. So what is the process to prove that ownership is still you're still having the outstanding financing loan which have not been even discharged or fully redeemed?
So that is the thing. As the liquidator on board, we just got appointed, so we don't have these documents. That is why we don't know which bank. If we go and ask the bank for the documents, of course they will not give it to us because you are the customer. We are not the customers, right? So that is why we want your lawyers to go to the bank, contact the bank, give us the documents, the CTC copies, and give us a copy so that we can process and we can verify on our end. Because we've been in this field for a long time. We've seen a lot of transactions which are incorrect. Just try to say the word fraudulent, which are incorrect. So we want to ensure that only verified purchasers get the fruits of this transaction over here.
Yeah. One more thing, because I think for the record purpose, is it okay for all these responses to the queries in case they're not provided in writing? Yeah, if you can, just for our own proper reference and review in the future. And the point 2, I think apparently most of the purchasers are pretty confused. Like me, I've been first and foremost called for this meeting. I don't know the heck and tail. So I think it's good that you gave us I seek your expertise, the guidance to give us step-by-step procedure as what to do immediately after this meeting. Who to contact, what to do. Can you?
I think the first thing you need to do is appoint your lawyer and tell him.
Yeah, I know.
Then
I know.
it's because
you have done a beautiful job. What I did just simplify it step by step. Just put an email, whatever contact you know, so that they'll be better guided.
Sure. We will be.
I appreciate it very much. Okay, thanks.
Thank you.
Sorry, Mr. Ya. You just draw an email to us, and we will reply to you by our letter. Then you will get a clear picture on this.
Sure. Please reply to me like that. I have rating those with all the relevant working constituent.
Please
and end up there's no response. Okay. So I will write to you.
We will reply to you. Thank you.
Yeah, we will. Thank you.
Can we take Miss Connie? I think has been waiting for a long time. Can we take Miss Connie?
Hello. Yeah, my question is because I do not know the procedure, so I already appoint my lawyer. It's just I want to understand. I do not have the full disbursement letter from the bank. What I have is a statement that how much the bank already disbursed to me. In my case, is it the document already sufficient to proceed with to request the supplemental agreement from?
Sorry, Ms. Connie. Let me take this question. Ms. Connie, first, please email to us. We will give an official letter to you. Thereafter, please appoint your solicitor. And we will guide your solicitor what are the information we need them to procure from the bank, your bank. Currently, your bank already released 60%, right?
90%.
90%. So we want a confirmation from your bank how much loan has been approved for your unit and how much did they already disbursed and what is the balance. Thereafter, we will guide accordingly. But currently, if you are servicing your loan, please continue to service your loan. Do not stop.
Okay. Another question is the supplemental agreement. I'm not sure whether anybody mentioned about the contents. I want to know whether the buyback option is written inside the supplemental agreement as well.
Yes, Ms. Connie, you're right.
So that one is confirmed. The HCK will offer the buyback after the completion. Is it?
Yes, Ms. Connie, the clause is there, but we are telling you all. We have drafted it in a very vague way. We don't want to be binding on you because 7 years from now, the price is going to be higher than $800. You're going to blame us and say, why did we lock out? You're only getting paid either way, you're going to be paid only upon completion. So many of our buyers, and like I said, we mostly act for about 500 over purchases. We don't want to be locked down knowing that the price in 7 years is going to be way over 800.
One last question is the timeline. So for the final approval, do you have any estimation when we will get the final approval so that we can?
So we're giving them like 1 year on top of the 5 years for completion after they get the approval. Like I wanted to say, Ms. Connie, I said this just now. Right now, we have just given them vacant possession of the entire site. This is the first time HCK is getting vacant possession from us. We are the liquidators for True Renaissance. Now that they have got the place, they are looking into the structural integrity. Some of the structures have been abandoned for so long, they don't know whether they have to tear it down or whatnot. So they cannot even put in the proper application if they have to tear down 1 or 2 blocks. We hope they don't have to, but they're still doing the structural integrity. So give us time. We are monitoring them every month. That's what the liquidators are doing. They are going to be monitoring them every month. They want to get started as soon as possible. They are businessmen, Ms. Connie. They want to start the project as quickly as possible because they want to launch. They want to launch and start collecting money as well from the unsold units. Ms. Connie? So all of us are in the same tandem. The faster we move, faster they make their money, faster you get your completed projects. Ms. Connie, I hope that answers the question.
Mr. Dana, talking about your issue on the structural integrity,
yes,
this is something very disheartening to hear about that after long years of abandonment. So is it possible you can tell which are the particular blocks that's under this questionable integrity that cannot?
You don't want, I know, but I don't want to tell you because you'll start a panic for no reason. Number 2, don't worry, sir. HCK has assured us, even if there's a problem with the block, they are going to tear it down and then rebuild it at their own cost. So do not get worried. All costs on them either way. It's just a question of time. The reason I'm talking about structural integrity is because everybody keeps asking, the 5 years starts from when? 5 years starts from when? So it's not easy for HCK as well. Sir?
So my last question, in your letter, email, you're saying that you're still in the midst of drafting the supplementary agreement, right? So
yeah.
When will the time you think is ready for us to execute it, and also at the same time we can connect well with our solicitor in case of that lah. So the timeline one we have to make it a perfect score lah.
Draft, we believe the final draft is this week, and HCK drafts have been going back and forth between HCK, Project Mora. All these drafts have been going back and forth. We think we'll finalize it this week. The master agreement has already been prepared, signed. Now we are finalizing the supplemental agreement, sir. Okay?
Can we take some questions from the chat room?
Yes, maybe just read out those questions, please.
Okay, with regard to DLBS payment, the purchaser is required to continue servicing the monthly rental interest payment. Yes.
I think Ms. P, can you confirm me?
Yes, I think Ms. P is replied to that, sorry.
Okay, next.
For buyback option decision, is it part of the supplementary agreement? Yes, I think we've already replied to this. It is part of the supplementary agreement. And you can decide at the time after the construction whether you want to take up this option or not.
Ramya, there's Mr. Kenny, I think, has been there waiting.
Oh, sure. Go on, Mr. Kenny.
Mr. Kenny, you want to still ask? Mr. Kenny, your hand is still up. I think I answered your question earlier. Did I?
对，因为它的那个原材料那个涨，就是说原材料那个涨嘛，就是说石油那个源头涨了，其他就是跟着涨咯。那个连锁反应的时候有时候很头痛。刚刚我发给你那个照片，你看到
You will have to appoint your own solicitor to complete the forms and submit to the liquidator, not to our firm, to liquidator, yes. And the 1,620 is imposed by the liquidator's lawyer. So you're paying directly to the lawyer, not to Ascentia Corporate Advisory. So just be mindful of that.
Hi, quick, sorry, I came
Yes,
back.
Mr. Kenny, go on.
Okay, just a quick question. I understand there's phase 1 and phase 2 and phase 3, right? So when you say that the 7 years means that, for example, if certain blocks are inside phase 1,
但他这个他不多啊，他就是要一套而已。
whatever not.
他在找一套就是对，他不是说找他们要可能就是说那个如果喝的话，那个价钱可以的话就用那个那种叫什么可热service 寄一套出来。他不是说整个货柜要做。
Yes. Mr. Raj, currently the entire project, the 8 blocks overall, it's sitting on the one development order.
对啊。
他
就是要找一套而已。他可能就是说，那个顾问说他之前有一个设备也是从中国那边来的，那现在他要找这个配件，他可能有问题啦，要找这个配件，那他也是用到一套而已啦，他就把这个图发给我，但是这个我们这边没有这样相同的。
They will write directly to Ascentia.
他就是要这样的 specification， 比如说就是一个电板。
Any of the purchaser need to register with Ascentia right now? The block number, the name, the contact number, anything like that?
Prefer your lawyer to directly write to us.
好的，就是说他们要需要找的就是跟之前这个最好都是一样的，要不然有些我知道他需要2个板或3个板但是他这个就是一个电板。
May I know how do we assure balance of my loan 50% to HCK are being claimed properly as per the percentage of work done? Ascentia will make sure of the progress claim.
Okay, so we
它
monitoring
就
this
这
where
两
we
个照
spoke
片而
about
已。
just now.
基本上它那
In
个
the
它
new
那个规
account,
格啦，
the
就是它
new
这个电脑的
billing
规格，就
account
在
that
那
has been
个
opened up,
另外一张照片上面有
the
写住的，
liquidators
写的
are
很清楚。
also viewers. We're
哈
not
哈
a
哈哈，
signatory
它
to
的
the
电呢是多少
checks,
多少
but we are
那
viewers.
个
That's
屏的
number one.
啊，什么
Number
的，
two,
它就
we
写
are
在那边
monitoring.
啊。
The liquidator has their own
好
technical
了好
side.
了，谢谢你哦。
They will be attending to
嗯
monthly meetings with
啊
HCK, right? And we are actually in conversation with HCK all the time because there are so many issues in terms of purchases, drawdown, documents. All these needs to be verified by us. So you've got to trust us that we are on the ball with all this. Yeah? Ms. Ramya, next.
We've got a question from Stanley Wu. What about this? What about same owner but multiple units? I'm assuming do they have to pay?
They have to pay for every unit. We go by units because we have no idea. Yeah, we don't have any proper list from True Renaissance, the original developer. What we have in our record now is as and when buyers come to us, we are building up a proper listing. The liquidators, this is what they do. And we only accept them as proper buyers when we are happy with the documentation forwarded to us. Next one.
We got a question from Mr. George Tan. My bank had released 90%. Do I need to top up the 10%?
Ms. B.
Sorry, you're still on the not done the deed of receipt and assignment, right, sir?
Yeah, he's saying that his bank is 90%. Yeah,
So
we the liquidators will be working with HCK to take your balance 10%.
Correct. We will request the lawyer to get a confirmation from the bank.
So
Thereafter, we will advise.
Yeah, you're not topping up. It's still the same price. We're just taking the balance 10%, not we, the HCK is taking the balance 10% from your existing loan.
Okay, the next question from Mr. Max. Is Richard B. Chamber the liquidator lawyer or do we need another one?
Yeah, if you're happy with Richard B, no problem. We work well with them. We'll just carry on with Richard B.
But Richard B, just to clarify, Richard B is not the liquidator lawyer. We have our own lawyer, Mr. Cecil and Associates.
Yeah, there are two separate law firms here.
Okay. When is the due date to verify purchases exercise?
ASAP. As soon they have to give as soon as possible.
We are looking at 6 months right now because of course if people don't come ahead as soon as possible, then we'll have to file a scheme of arrangement. So please provide your documents. Give us your liquidators. Your solicitors within 6 months at least. We can process and go ahead.
So let me explain this. Let me just add on to what our colleagues are saying here. We keep talking about 2,000 units. Let us be honest, apart from 500 to 600 owners, we really don't know. Today's meeting, you can see a few people have turned up for the first time. We don't know who they are. We don't have their records. It is you buyers sharing the link with other people, which is fine. We want to know all buyers as soon as possible. So this is why, this is all the more reason why we need to get the initial group, those under Richard B or under Hakim Arabi previously, we want to finish or get that work out of the way so that at least we can file the scheme of arrangement. If we wait until the very end for 2,000 people to come forward, it's never going to happen. HCK is going to start blaming us and saying we're not doing our job. So please, the faster you come forward, the better it is for everybody. Thank you.
Ramya? Hello?
Yes, ma'am, go ahead.
The balance of the billing after all the plans and everything already approved and construction started, then the billing will be issued by Subang Central or by you liquidator?
The billing is issued by the architect. The architect will issue them.
Architect will issue the architect cert, but the billing should be from the developer. So
yeah, correct. It's the new developer, Subang Central. They are changing their name. They are the one who will be issuing.
Yeah. So we only liaise with you up to the supplementary agreement, right? And subsequently, we will liaise with the developer, Subang Central, after that?
No, miss. We will time to time will update your lawyers and your lawyers have to be notify the banker on the progressive billing. We need a reply from your bank first on the loan amount. Thereafter, we will advise accordingly. Currently, we want to know how much loan has been approved and balance loan amount so that we can notify HCK and we will advise them on the progressively.
I know. My question is, from now we liaise with you, right?
Yes.
And do not have to liaise with Subang Central?
No. You have to liaise with them directly.
Till they finish the project?
Yes, you are right.
Taken possession also we still liaise with you?
Yes. Yes.
Alright.
Miss B, they can't see your face, Miss B. Can you?
Yeah, Mr. JC, Ramya.
Mr. JC, go ahead. You can unmute and ask your question.
Sorry, a bit off topic, but is anything being done to investigate and go after the directors or the architect, the previous architect?
I think this question everyone asks is a bit too late in the day. Nobody took action earlier except for two law firms, I believe, went after them, and that's how we came to this compromise. So it's a bit too late now to go back to the beginnings. Yeah. Okay, can we
Mr.
move?
Dana, Mr. Would you mind? I just want to confirm your earlier statement.
Yes.
So I'd like to confirm that my housing was previously dispersed at approximately 92% to the former developer. So the remaining 8% balance will be released to SCK as a current developer, or rather so-called by night.
Yes.
Now, upon completion of this arrangement, the full purchase price is deemed as fully settled. Treated as it had been fully paid directly to SCK. Right. Notwithstanding the earlier disbursement to the previous developer. Am I right to say that?
Yes, you're absolutely right, sir.
Yeah, thank you, sir.
We've got a question from Max. So is that mean if Richard V. Chambers is preparing the agreement, we no need to engage liquidator lawyer?
Again, they don't understand. Liquidator's lawyer is payment for the liquidator and for their lawyers. Richard V is not preparing anything. Let me be honest with you, Richard V is not preparing anything. The liquidator and their lawyers are preparing the master agreement, supplemental, scheme of arrangement. What we are asking you all to do is get your own lawyer merely to assist in liaising documentation. Yeah? So they're not really preparing anything, but they're going to assist you talking to the banks, your own end financing banks. You don't know who is your banks. So please understand the distinction between liquidators and your own lawyers. Yeah? You are definitely paying the liquidator through their lawyers. That is Susilan Associates. You have to pay. If you don't pay, we will not recognize anyone as a buyer until we receive that payment. I hope that is clear for everybody. Yeah? Your own lawyer is up to you. You're paying 1 ringgit or 10,000, we leave it up to you. Or whoever you pick. But liquidator's lawyer is non-negotiable. Everybody has to pay. Thank you.
Can I just ask, when are we expected to make a payment? Solicitors.
As soon as, we keep saying that you have to first lock down your own lawyer, whoever is going to be your lawyer. Sir?
So we wait for the invoice or what?
No. You have to first decide who's going to be your lawyer. Sorry, I can't see who's talking, Ramya. Can you help me out here?
Mr. Ong.
Mr. Ong Boon Hock.
Yeah.
Okay, Mr. Ong, you have to first decide who's going to be your own personal lawyer in this whole thing.
Well, we have, just like many of them, we have appointed Richard V. Chambers to represent
then
us.
You can do. Yeah, just talk to Richard V.
Okay. Thank you.
Thank you.
Actually, my name is Shami. Okay, I just checked with Richard V. So if I understand correctly what she said, that already when I paid the 1,620, which is the letter of engagement, that will be our appointed lawyer to deal with the liquidator solicitor. So if you all are like me, that already paid for the LOE, means you already appointed Richard V as your own lawyer. Okay.
Correct.
Thereafter, just to clarify, I'm just giving you the SOP. Thereafter, Richard V will write to us saying that we are the lawyers for such and such ABC. So once we get that letter, we will write to Richard V with a comprehensive first letter where we'll inform them that what you'll have to give us these following documents. This is the cost,
1,620 is the cost, which bank account to pay, and we'll also give you the specimens. So once your lawyer writes to us, only then are we able to send you that first letter, because of which is why we are having this confusion. Without you appointed a lawyer, we cannot send you this first letter. Right?
So what I understand is I already appointed my lawyer, I paid the lawyer fees, and then I have to wait for my lawyer to connect with you guys, and you're going to send another new invoice for the liquidator's service fee, right?
Yes, we will give you a comprehensive letter with all the details that you need to know. What you need to do, what documents you need to get from the bank, confirmations from the bank, all the specimens. We'll give you everything in that first letter.
Thank you.